I'm bringing him by a leash.
I don't want to go.
So welcome everybody, and I also want to welcome those of you that are home who are either watching this live streaming or recorded. It's nice to have you here. We're going to reflect upon the current state of Alaska law relating to abortion, and I looked at it as something that was going to take me several days to prepare because I'm only vaguely familiar with it and not from a legal perspective, just really from anecdotally. But I knew that Bob Flint was very up to date on the law and has worked in this area advocating for the unborn. So I really welcome him. One of the important things that I think that we should always emphasize in matters of life like this is that we have a consistent ethic of life, which means that we care deeply about unplanned pregnancies and their impact upon moms. We care about supporting families, particularly poor families that need support, and that we care about life as a whole. And I'm pleased to say that the way that Bob and I got to know each other was through social service work here in town. Bob was really the instigator who went to Archbishop Hurley. How many years ago for BFS? It's been a long time.
Oh, it's in I think BFS opened about 82, so maybe it was about the year before, something like that.
So in 1981 or so, Bob found there was a homeless person that had died by a dumpster at Holy Family Cathedral. And he went to Archbishop Hurley and said, we've got to do something about this. Well, he's a man of action, and they did. And so he actually founded, with Archbishop Hurley, Brother Francis Shelter, Clare House, which for those of you who don't know at home is the shelter in town for moms with children, and then also Covenant House, which is amazing. And he was the board chair at Covenant House for like 25 years or
13, but I was on for 34 years.
Okay, so 13 years as the board chair, the first 13 years of it, and so deeply, deeply committed to the social ministry of the church and the importance of supporting those who are in need. So for me, it's always been just a great privilege to call Bob a friend and one who we share values together about the importance of all of these areas. So thank you so much for saving me 2 days of work this week, and you're going to do a lot better than I would have. Okay, here's your leash back.
Okay, thanks.
There we go.
Okay. Let me raise this up a little bit, Scott, just to, the older you get, the closer it has to be.
Pull up on it.
I hear some people who agree.
I'm not sure if that's going to go up.
Oh, that's as high as it goes?
Yeah, this doesn't seem to be working. Can your old eyes see that?
Oh, sure.
Is it too far away?
No, that's all right. I can pick it up. Well, thanks very much, Scott. And I listened to Scott's presentation last week and thought he did a great job on not only a complex subject, but holding interest on a legal subject, which is intensely boring to everybody who's not a lawyer and being paid for what they do. One of the guests we had up, oops, is the sound all right? Can you hear me?
Okay, it's on. I just wanted to make sure.
Oh, okay. The lawyer who had worked with now Justice Kavanaugh, as a law clerk, came up to talk about him when the nomination process was on. And he was, at that time, and he's now on the Circuit Court of Appeals, so he came up himself. But he was a professor of legal writing. And, you know, I didn't comment to him, but I couldn't think of anything that would be more worse to be than a professor of legal writing. You know, briefs written by lawyers are bad writing, and they have no interest to anybody except the litigants to the case. You know, and once in a while there are some figures in the law, most famously Justice Scalia, whose one-liners and opinions were worth reading just for his ability to skewer his opponents and make you laugh about it. But alas, the rest of us attorneys can't do that. Well, what I want to do today is cover several points. Want to go superficially and quickly through the history of abortion in Alaska. Then talk about a couple of issues: parental notification and public payment for elective abortions, which went its way through the court system for decision. Then talk about our privacy amendment, and then choosing judges. Now, to start off and give you the ultimate conclusion, after Dobbs, which eliminated Roe versus Wade and its companion case, Casey, and turned the issue back to the elective bodies, the legislatures of the state or the Congress, rather than the judiciary. So how has this changed what is going to happen in Alaska? It doesn't change it at all. Alaska has long been on a spectrum of abortion which is even farther away than Roe versus Wade was. And it is very determined on that, with few exceptions, and that simply isn't going to change unless you can get some change in the Constitution or change in the Constitution of the courts, which are very, very difficult, if not impossible, and I'll go through that. But just to build on Father Scott's comment on my biases, I have been a member of the Alaska Family Council, an ecumenical group which works on life, family, and religious liberty issues since 2006 when I joined the board. So I have been involved in the political sphere with the Alaska Family Council on promoting life issues under Alaska law. Now, the brief history of abortion in Alaska is that there was, inherited, I suppose, from territorial days, a restrictive abortion law in the new state of Alaska. But about, I'd say, the mid-60s, legislation was introduced and passed in the Alaska legislature to liberalize those laws. Then Governor Keith Miller vetoed it, but it was overridden by the legislature, so it came into law. But it was a very public, controversial issue. Then a short time later, in 1972, the Alaska voters passed a constitutional amendment creating a right to privacy. Now, this makes a difference. Before it was rather superficial difference, but what Roe versus Wade and its predecessor case, the contraceptive case, Griswold versus Connecticut, did was invent a right of privacy in the U.S. Constitution out of whole cloth. It's not there, you can't find it. It was invented for a specific purpose, because whether in the contraceptive case or the abortion case, they couldn't find anything in the Constitution that really fit. So the courts have a lot of rules that they mostly make up themselves, some of which are in the Constitution. The Constitution ones are equal protection, due process. There are rules like undue burden, strict scrutiny, and a whole bunch of other rules that you can really consider as a toolbox. And if you want to fix something or make something, then you reach in your toolbox. You've got a lot of tools, and you pick the one that will fix the thing or make whatever you want to make. And if you can't find one, then of course you can make up another rule, or you can make up another tool that will do it. So that's what those rules are for. They often tend not to be rules that examines the facts under a known law or situation, but they will be the excuse for getting the results you want. And the courts basically use that all the time. So then, the basic rule of abortion under the Alaska State's Court vision is a complete bodily autonomy for a woman in choosing whether or not to give birth in any manner, shape, or form. That's a lot broader than the U.S. Supreme Court. So for those of us who are trying to approach it in a legislative way or even a constitutional amendment way, it makes us go around the edges of, and not go to the core of the thing, because it would really be impossible to overturn what the Supreme Court has in the state of Alaska. But perhaps when you look at trying to deal with life issues, there are ways that you can promote life without going the whole way. And there were two of them in which the Alaska Family Council Family Action Group promoted. And those of you who've been around for a while maybe remember them. One was parental notice. And that's where a law requires, before a minor can have an abortion, that their parents must be notified in advance of that procedure and at least have the opportunity to discuss that with their minor child. The second issue is, does the state have to pay for elective abortions? And there was a statute that was passed that prohibited the state from paying for elective abortions pursuant to one of the opinions that I'm going to go through. Then I'll discuss the Privacy Amendment, how it came to be and how its meaning came to change, and how we choose judges, which is the only way you can change law here in Alaska. So going to the first case, back in 1997, the Alaska legislature passed a parental consent law. Now, unlike parental notification, which is just a notice, parental consent means that the minor child has to have the consent of the parents before a doctor can perform an abortion. In 2007, the Supreme Court declared that unconstitutional. State Supreme Court, I'm sorry, yeah, State Supreme Court. Unless I refer to the U.S. Supreme Court, I'm going to be talking about the state courts now, because that's the court we're playing ball in. So they declared it was unconstitutional because it violated the right of privacy, which was this wide autonomy business, and it meant that the minor child would have a veto possible given by their parents, which was unconstitutional. But there was discussion, and actually a fair amount of discussion in the decision, writing in the decision about parental notification. And I want to read some of the quotes to you, because this is what we took as an invitation to go work on a parental notification law. And this is Justice Dana Fade, who appears in these cases very often. She says, there exists a less burdensome and widely used means of actively involving parents in their minor children's abortion decisions, parental notification. The United States Supreme Court has recognized that notice statutes are not equivalent to consent statutes, and they do not give a veto power over the decision. And many states currently employ this approach. Let's see. A review of statutory schemes are enacted around the nation reveals a widely used legislative alternative that does not shift a minor's right to choose parental notification. Although such parental notification statutes undoubtedly burden the privacy rights, they do not go so far as to shift a portion of those rights to the parents. Notification statutes protect minors by enhancing the potential for parental consultation concerning the decision. Parents who do not possess a veto power over their minor children's abortion decision have a greater incentive to engage in constructive and ongoing conversion with their minor children about the important medical, philosophical, moral issues surrounding abortion. A notification may actually better serve the state's compelling interests. Well, that sounds like a pretty good review of parental notification, coming from the opinion of the person who is ruling against consent. So we perk up our ears at this language. And it looks like to us an invitation to go work on a notification statute. And it's very much like your final in college. If you really want to get a good grade, what do? Well, you look back at your notes and see what the professor said in class. And then, when the question comes up on the final, you parrot the professor back to the professor, and therefore, presumably, he approves of your excellent answer and then gives you a better grade. So the technique is the same here. If Dana Fabe says we can't do consent, but waxes on how wonderful notification is and helpful and it's not the same, what do? We go to notification. So that's what happened. We organized an effort in the state legislature to pass a notification bill, but we couldn't get past the roadblock of the pro-abortion bloc. So we went to the initiative, which of course is much harder. I mean, this is a statewide initiative. We had to spend a lot of volunteer effort and money to get petitions across the state and then fight an election about it. But it was successful. 56% of the people in Alaska voted for the parental notification. So it went into effect. And as usual, after a few months, it was followed by a lawsuit by Planned Parenthood asking for this to be declared unconstitutional. And in fact, that's what happened. They did declare it unconstitutional. And why did they do it after what they said in the first case? Because basically we decided, this is what the judge said. Let me see if I can get the quote on that, just a minute. They went to another toolbox. They went to equal protection. And what they said was, well, we decided the other case under the right to privacy, but we didn't say anything about equal protection. We did not address other constitutional issues that might arise from a notification law. And sure enough, equal protection does infringe on a person's individual rights, and therefore this is unconstitutional under equal protection. Now, in non-legal terms, that's called a gotcha, by the way, we didn't talk about this. We only did it favorably under this principle, but under this other principle, it's unconstitutional. Thanks very much for giving us all the work to do something that you knew was going to be declared unconstitutional. Now, and even Dana Fabe voted for it being unconstitutional because she didn't think the law was good enough to suit her narrow standards. I believe that the Alaska Constitution permits parental notification law, but not one that contains provisions that are most restrictive of any state notification laws. Therefore, it violates the Constitution. You almost want to ask her, well, would you please draft us a statute and put it in the mail so we could get one that would satisfy you? But there was a dissent by Justice Stowers, and I'm going to quote this one because I think it really tells the tale. By the way, the other hopeful thing was that the consent law was 3-2, and we had 2 dissenters which wanted to uphold it. So by going to a lesser thing, we thought it should be easy to pick up that other vote and make the case good, but it wasn't. But here's Stowers. I disagree with the statement that parental notification does not achieve the goals using the least restrictive means. Whether a method is the least restrictive means of achieving state's compelling interest is in the eye of the beholder. What one judge or policymaker considers to be the least restrictive means of achieving a given goal may not seem to be the least restrictive means to another judge or policymaker. Based on their individual experiences, how they weigh the given evidence, their personal values, whether one policy is less restrictive than another typically comes down to a value judgment. The Alaska Supreme Court's persistent use of an ever-narrowing means to end test in these parental consent and notification cases demonstrates that when the test passes the limits of reason and common sense, the test loses whatever legitimacy it may have once possessed. The quest to discover lesser restrictive means to accomplish the state's compelling interest at some point becomes self-fulfilling. There can always be found some lesser alternative that might have been employed, and thus every legislative enactment touching upon abortion can be held unconstitutional, whether under the rubric of a right to privacy or equal protection. The court's lesser restrictive alternative analysis today reminds me of Zeno's paradox of the race between tortoise and Achilles, purporting to prove that the faster runner can never win the race because when one artificially divides the distance of the race course in half and again ad infinitum, the runner can never cross the finish line because there will always be some small incremental half distance remaining. I'd say exactly. It's again, if that's what they meant, just to be even courteous rather than send us on this wild goose chase, they should have told us in the first place. The second matter involved elective abortions, and here we have Dana Fabe again. She ruled that a state law did not properly cover funding for medically necessary abortions. That's the term she used. She had basically a half a page that described what those were, specifically listing examples. And then she said a half a dozen times, the state does not have to pay for elective abortions. It came back to the Supreme Court, of course, in 2019. Fabe is no longer on the court. And they decided it was an equal protection argument besides a privacy argument because the fact that the state would pay for a pregnancy carried to term and not for an abortion would be an influence that would persuade the woman who didn't have the money to do it herself, to go to the pregnancy term because it would be paid for. The disparate restrictions on government funding for women based on the choice of either abortion or childbirth deter the exercise of a fundamental right because pregnant women in that position are locked in a binary dilemma. The rejection of one option inevitably entails the embrace of the other. Again, Justice Stowers dissented, reminding them that the previous decision specifically said no elective abortions needed to be paid by the state. So we're really back to the point where the spectrum has almost gone 100%. There's little, if anything, left we can do or the people can do legislative or by lobbying their elected representatives. So unlike the Dobbs decision, whose characteristic was the judiciary does not belong in this fight, it is time to return these decisions to the people through their elected representatives, both at the federal and state level, and not us. The Supreme Court of the state of Alaska has gone the other way. Regardless of what it is, the decision will be theirs, and it will be always for the abortion side. So, okay, what can we do? I'm going to go in that in just a second, but I want to discuss a little bit about the Privacy Amendment. The Privacy Amendment, as I said, is a pretty simple one. It simply says the right of the people to privacy is recognized and shall not be infringed. Something that I think most people would agree with. But the amendment was much different when it was first proposed. And it was shepherded through the legislature by the then State Senator Terry Miller, who I was acquainted with. And even though it's long ago, I remembered that it was aimed at informational privacy. But by the time it got to the vote, it was much broader. Last September, there was a column by Steve Haycock, who was a professor of history at the University of Alaska, and a regular columnist at the Anchorage Daily News. And he was commenting on John Havelock, who was Attorney General for some time, Deputy Attorney General when I was first in the AG's office in 1963, and many other roles, and a certified progressive. He died late last year, and this was an adulation piece for John Havelock by Steve Haycock. But and I'm going to read it. It's about 3 paragraphs long. John anticipated the long reach of the Privacy Amendment to the Alaska Constitution he wrote when he was Alaska's Attorney General. He told me not long before he died a month ago. The chief concern was to protect vulnerable citizens from illegal and unwarranted wiretaps and from computerized and other electronic surveillance rapidly developing. But since the approval by the voters in 1972, the Alaska Supreme Court has interpreted the right to privacy broadly, finding it protected home use of smaller marijuana, various aspects of certain search and seizure, but perhaps most timely, the court has found in several cases the privacy right protects a woman's right to abortion. The amendment is remarkable in its simplicity. Havelock told me that Terry Miller came to him with a much lengthier version of the amendment, recognizing that specific wording, the more specific the wording, the more likely the issues that could be covered might not be. So Havelock shortened the amendment to the version that the voters approved, which amounts to a near universal protection of Alaskans' privacy. Countless Alaskans owe a debt of gratitude to Havelock for that, including the women who seek an abortion in the state. So Miller and his supporters had no intention of opening up the door that wide. So an intervention by one guy who happened to be in the right place in the right time changed the whole aspect of the amendment and transferred, again, the power from the people to deal with in the legislature to the courts. And that's where it remains today. So the final one, what can we do? Well, I think the answer probably is nothing. Dobbs came about changing Roe versus Wade because the Supreme Court changed. It changed because there was a change of personnel and adopted a different philosophy. The rise on the federal level of originalists and textualists who maintained that the words of the Constitution mean in context what they did, what they were written in, and by adhering to that, you put a fence around the judges to prevent them from going off and doing anything they want. And then to change the Constitution, you have to go the normal way, which is amend the Constitution, in which the people are involved through their state governments. But that means, of course, you can under the federal system, the judges, even though they have lifetime tenure, and therefore are free to do what they want for many, many years, their appointment process is connected to the public because they're appointed by an elected official, the president, and they have to be approved by elected officials, the United States senators. In Alaska, the Missouri plan gives the control of the selection of judges over to the lawyers. They are picked by a judicial council which has 7 members, 4 of whom have to be lawyers. 3 of them are elected by the bar itself, and 1 of them is the Chief Justice. And the outcome is predictable. I mean, judges are, fairly well known to being more progressive than the rest of the electorate. And in fact, a year or 2 ago, just to test that out, the Alaska Family Council hired a private firm dealing with statistics to do an evaluation of the registration of attorneys versus the state registration list of all voters. And it turned out that, in considering the 2 major parties, Republicans got about 64% of the electorate, and the Democrats 36%, and for the attorneys it was exactly the reverse. In other words, almost 2 to 1 Republican over Democrat in the electorate, and the reverse 2 to 1 of the lawyers, Democrats over the Republicans. And if you look at the respective platforms of both state parties, you can see the difference. And if you look at the decisions that are made by the Supreme Court, especially on abortion, they follow right down that line. But to change that is near impossible. The people cannot propose constitutional amendments by initiative. It has to be by 2/3 of the legislature, and that's very difficult. You can do it by constitutional convention, which is up this year, but those have typically been turned down because people are afraid of opening it up to all sorts of stuff. So the answer is, I guess there's no answer. So maybe I should stop there and see if you have any discussion you would like, or questions, or anything else.
Bob, is there a time frame limit on when an abortion can take place in Alaska?
Time limits? You mean
So obviously,
Oh,
allowed in regulation under Roe. Could you repeat my question so people at home can?
oh, okay.
But for instance,
Are there time?
someone get an abortion in Alaska at 8 months.
The question was, are there any time limits on having restrictions on having abortions in the state of Alaska? The Roe versus Wade setup started off as a trimester deal, whereby in the first trimester you could have abortion, no restrictions. Some restrictions in the second trimester and third trimester, you could even supposedly outlaw it in the interest of what they called potential life. They changed that in Casey to undue burden. So it's sort of a floating type of structure. But the fact is, under Roe versus Wade, there were some restrictions that presumably the state could enact. But the state Supreme Court has never adopted anything like that. They have always said it's a fundamental right, and it's a right all the way through the whole period of the pregnancy. And they have never even referred to anything about potential life or the life of the child, or that would have any consideration at all. So there haven't been any cases I know of, about late-term abortions, and I don't know what the situation is in reality, but given what the state court has done, I'm fairly confident as to the way they would rule, and that would be it's unrestricted. But, yes.
If you could repeat, because I didn't understand, about the parental notification and whether they have, the state will pay. What is the decision? Are parents notified? Now, if a minor wants to have an abortion, do they have to have parental notification?
There is no requirement. In fact, they have. Huh?
Repeat the question.
Okay, so say it over again so I can make.
Well, I just wanted to confirm what you had said, that there is no parental notification required
Yes.
for a minor, and the state is required to pay for the abortion?
The question was to confirm that there is no state notification requirement. That is correct. Yeah. Now, as far as state paying for abortions, yes, they are required to pay for it. Now, this is under the Medicaid program, that is the welfare program. I mean, the state doesn't pay for everybody's abortion, but it does pay for those who are getting the welfare payments or under the regular medical thing. And yes, they have to pay for the elective abortion, any abortion, period. Yeah.
Okay, thank you.
Yeah.
Thank you. This was very helpful, both you and Father Scott, going through the tedious process of explaining to us the history of abortion and all the laws and Bill of Rights, the amendments. And I want to confirm two things. On our constitutional amendments, is there no right to privacy? Was that what, the state, you were clear, we have a right to privacy.
The state constitution is,
But
yes,
Supreme Court, federal law, it's not in
it
there?
does not.
Okay, because implicitly, even in looking at that piece of paper you gave us, Father Scott, I don't think it said it on there, but you focused on liberty, I think is the key word. So I have another question that is just warn you is controversial. There has been a lot, not a lot, but some in the press about the fact that Roe was a settled precedent, quote unquote, at the federal level. And that I don't think was in any discussion. And it seemed like the current Supreme Court had chosen to ignore settled precedent, even though 3 of the judges had said they accepted Roe v. Wade as settled precedent. Could you comment on that?
Yes. Okay. The question is on, the second question is on stare decisis, which is let the previous decision stand, even if it's wrong, because it's been relied on by a lot of people and so on. Now, and stare decisis is a doctrine that is commonly used. However, I was once at a session, a summer session on separation of powers given by Justice Scalia, which was a real treat, let me tell you. In fact, afterwards, we had cocktails, and I was standing there with 2 or 3 other people like this, talking with Justice Scalia, and boy, I wouldn't have missed that for anything. But Scalia said that stare decisis is used almost always for statutes and not for constitutional issues. And the reason is pretty clear, because if the court has ruled on the interpretation of a congressional statute and the Congress thinks it's wrong, they come out with another amendment, another statute, basically saying, look, this is what we meant. So they have the corrective point. But to use stare decisis on a constitutional issue means in reality that the court itself has amended the Constitution, and even if it's determined that the reasoning was wrong. Justice Alito went into that pretty thoroughly in the Dobbs decision. And he said that in order to do it constitutionally, it's not just time or even reliance, it's how this was rooted in the country's history. In other words, that this has been around for a long time, and it's not just something that was thought up and then imposed upon people. It has to be rooted in the history of the country. And he went, and it's worthwhile reading that part of his opinion, because that is really the basis for the Dobbs opinion. Roe versus Wade was so far out of whack and so invented that it simply wasn't appropriate to keep in effect, because it would have meant that the court has the privilege of amending the Constitution and can get away with it, and that's wrong. But Alito, much more eloquent than I am, and I think from an historical and other purpose, you would find it worthwhile to read that part of the opinion. And it has some life to it. Alito is, he doesn't quite use the zingers like Scalia does, but he's acerbic, and you can tell he has a lot of passion into it. So it's worth reading. Did that answer the question? Yeah. Anybody else? Well, thank you very much. I hope it was informative.
Let me get your,
Oh,
let me get your leash.
Oh.
Pull the leash out. So anyway, wanted to just thank Bob. And, again, I looked at trying to get prepared for this, and I said, I just don't have the time this week. But I knew that he would do a lot better job than I would. And actually, if you go back to my talk, when I talked about stare decisis, there were 5 different principles that were in the Dobbs decision, and I did go through those. It's probably just the stare decisis didn't click with being precedent, but that's what that whole discussion was about, that there are 5. And remember that you don't have to read the 100+ pages of the Dobbs decision and all the dissents. You can read the first, I think it's 12 pages that are the syllabus. It's either 8 or 12 pages. And you'll see a summary of stare decisis in the syllabus as to them going through that. So, yeah, good. So thank you so much, Bob. And thanks for all your service to our community. Good. And God bless everybody online.
Thank you.